Welcome and good morning, good afternoon, good evening, wherever you are. I am Hannah Shea, World Law Group's Manager of Communications and Network Development. Thank you for joining us on today's webinar on understanding SPAC transactions. Before we jump into the topic, I wanted to give a really quick overview of World Law Group for those of you who may not be familiar with our network. We are a leading network of independent law firms across the globe with 61 member firms and more than 21,000 lawyers in the network. We collaborate globally in our 17 practice and industry groups, and in 2020 shared almost 3,500 referrals among our member firms. Just a few housekeeping items. You are muted and will remain so throughout the duration of the meeting. We will have time for questions at the end, but I ask that you please put those in the Q&A feature. You can put them in the feature throughout, and we will moderate those with our panel. The session is being recorded, and it will be available on our website shortly after this webinar. I will now hand this over to our moderator and co-chair of the VC group, Alan Goodman of Goodmans in Canada.
Thanks, Hannah, and welcome everybody. Thanks for joining us today. The topic is, we know, has got a lot of interest in that there have been a number of SPAC transactions been taking place, particularly in the last, say, 12 to 18 months. And although, unless you practice in this area on a regular basis, people have some anecdotal information or understand it in some form or another. But we're lucky today to have a panel of experts across the globe. Two from North America who deal in actually the formulation of SPACs and on both sides of the transaction, whether it's the SPAC or the target. And then we've got a couple of panelists from around the world who have been acting on the target side and understanding some of the implications when you're acting on that front and how to best get your client ready for the transaction and how it may work in your jurisdiction. So we think by having this diverse group of panelists, you're going to be educated from both sides, and if you to the extent you have questions, we invite those. We're going to take the position in some cases of being pretty starting with a low level of information, but if you have specific technical questions, don't hesitate to ask. The idea here is to inform you as much as possible, so to the extent you get involved in these transactions, you come away with this with a little bit more information than you started with. So with that, I'm going to introduce the panel. Megan Fiscaldi is an associate with Lock Lord in Boston. She counsels clients in a broad range of securities transactions and has extensive experience in U.S. debt and equity capital markets transactions, including SPACs. David Cole-Black is my partner here at Goodmans in Toronto in the business law group. He focuses on corporate and securities laws. He's been involved with SPACs since they first emerged in Canada in about 2015 and has worked on a number of SPAC IPOs and de-SPAC transactions, which we'll talk about. Roxanne Anderson is a partner with AZB and Partners in India, based out of Mumbai. Roxanne is an M&A and private equity transactional lawyer and advises a large number of Indian and international clients on domestic and cross-border transactions. Roxanne is currently advising CPPIB, the Canada Pension Plan Investment Board, who is a significant minority investor in Renew Power in connection with Renew's ongoing NASDAQ listing via the SPAC route. And she'll have some terrific insights with that transaction and others. Erez Abu is a corporate partner at Herzig Fox and Neiman, Israel's largest law firm, specializing in cross-border M&A and investment transaction in various sectors. Erez advises a variety of Israeli and foreign clients, including multinationals, VCs, and high net worth individuals. Since 2019, Erez has been focusing on SPAC transactions, advising clients in different roles of the scene, including SPACs, targets, pre-SPAC financiers, and PIPE investors. And Israel has had a number of transactions go this route, and so Erez's insights will also be incredibly helpful for all of us. So with that, first of all, thank you to all the panelists for joining us. We really appreciate it. We're going to start with Megan, and we're going to just start very generally. For those who may be coming to this with very little knowledge, what is a SPAC and some of the benefits of going public as a target of a SPAC? So maybe you can just start with sort of SPAC 101, Megan, if you could.
Yeah. So SPAC stands for Special Purpose Acquisition Company. A SPAC is a newly formed company, no assets, no operations, generally does have an experienced management team, Sometimes that's in the form of a corporate sponsor, or just sort of a management team of people that have worked in a particular industry and have expertise in a given area. And that newly formed company is taken public it raises money with usually the securities that are issued in the US are in the form of units, which consist of an equity component like a common stock, common share, and a fractional warrant. The money that is raised in the SPAC IPO is for the purpose of acquiring a target company, usually with a sort of generally limited time horizon. And typically, we've been seeing about 24 months that SPAC entity that's newly formed goes public has to acquire a new target company. The IPO proceeds are typically put into trust so that while the business is seeking a target, that money is sort of in a safe investment. And there's usually a redemption right of the stockholders once the target is identified and they begin the de-SPAC process with that acquisition target. There is a redemption right for stockholders if they don't like the target that's been identified or don't think that the value is there in that transaction. As Alan mentioned, one of the reasons why SPAC is sort of such a hot topic is because the use has really exploded, particularly in the US over the last couple of years. They've been around since the 90s in the US with maybe a dozen or so a year, going to a few dozen a year in about 2018, 2019. Last year, there were about 250 SPACs that were formed and went public, and there were about that many in the first few months of 2021. The IPO markets have slowed a little bit in the US, so there are not as many SPACs going public as we enter the second half of 2021 in the US, though I know some of the international markets have taken off a bit. But there still is a robust pipeline of SPAC IPOs in the works, and that market is expected to come back at some point. And there are, as a result of all of the SPAC IPOs that occurred, several hundred SPACs in the US that are looking for targets to effectuate a de-SPAC process within a period of the next 18 to 24 months. Speaking a little bit about the benefits of going public via SPAC versus a traditional IPO. Generally, companies can raise higher cash proceeds in a SPAC IPO. That's due to a lot of times SPACs being coupled with PIPE transactions or which are private equity raises at the same time as the de-SPAC merger. So there's the opportunity to basically combine a late stage private investment round with the public equity raise, which you don't typically have in a traditional IPO. There's also some more marketing flexibility in a SPAC IPO. There's flexibility to disclose future projections, which is particularly beneficial for targets that may be pre-revenue. And you can also leverage, if you're working with an experienced sponsor and going public with a SPAC that has a management team that has a lot of expertise in a particular area, you can leverage a lot of the sponsor's strengths in connection with your IPO process as through a SPAC merger. Can typically be faster than going public via traditional IPO, though that can depend on a number of factors that we'll get into a bit more through the course of the presentation. And another additional sort of benefit is there's more price certainty than in a traditional IPO. A traditional IPO is priced at the market on the date of the IPO. That can be subject to a lot of market conditions and things that are not necessarily able to be predetermined. If you're going public via SPAC merger, you are locking in your merger price with the SPAC. So there's a bit more price certainty in that respect. So those are some of the key benefits and reasons why I've seen targets sort of choose this process versus a traditional IPO process.
Thanks, Megan. David, the Canadian market came along a little bit later, and maybe you can just talk about, because this is sort of a North American phenomenon now, a bit of an overview of the development of that market and maybe some of the differences we've seen between the Canadian process and the US process.
Yeah, so the SPAC rules, there's two stock exchanges in Canada that have SPAC programs. The Toronto Stock Exchange developed the SPAC rules in 2008, 2009, roughly, right in time for the financial crisis. So I think there was an initial push to develop a SPAC market, but that obviously didn't take off at that time. The first wave of SPACs really was 2015. I think there was about 5 or 6 SPACs that emerged, and then subsequently there's been a few other waves. But over the years, it's becoming much more consistent. This is becoming a product that the Canadian markets are really familiar with, and the consistency of IPOs is picking up. It still is much smaller than the US, simply due to our capital markets being smaller. I think Megan mentioned, over 200 IPOs, SPAC IPOs in the US last year. I would say in Canada there was probably 5 or 6. So it's still developing, but it is becoming a consistent or a more familiar product for the Canadian market.
So Roxanne, looking from a target's perspective, what makes, we can speak to India, but some of these factors probably reach across different jurisdictions, and I invite others to pipe in. But Roxanne, what makes SPAC transactions attractive from your jurisdiction's perspective?
Sure. I think, Alan, I think in the Indian context, and Megan touched upon this a little bit earlier as well, but I think primarily having the ability to access international markets, I think is hugely attractive in the Indian context, particularly for a lot of the slightly newer age sectors, so consumer tech, for example, where the markets are just not perhaps as deep and as developed in terms of pricing. The ability to rely on, as Megan said, future projections, for example. I think all of that makes it quite attractive. And then the ability to access potentially the PIPE investments, and I think also coupled with the highly shortened, at least in the Indian context, and much simpler route than what we have for India. I think the eligibility requirements, generally speaking, for an IPO in India are not particularly easy to achieve. It can be quite a cumbersome process, and having the ability not only to access international markets, but then to do it through this shorter and more straightforward route is, I think, what really has started getting people excited.
That's great. Erez, maybe you can talk about some of the immediate challenges that target companies face when they're considering the SPAC route. What are the things they have to consider upfront in order to get themselves SPAC ready?
Yes. So maybe one word regarding the previous question that I think is important for founders. So I think we usually in the process of a startup company, there is a pressure from early stages for exit rather than the IPO route, which is seems more cumbersome and longer. So when there is a pressure from SPACs on companies to go public, then the founders see the long-term incentive here, and they can also capitalize on liquidate their holdings, have easy access to liquidation when they need, and even benefit from ancillary secondary sale. So this is very good for founders, I believe, and also very good for local markets, because usually in Israel, at least, many companies found themselves doing this exit, and much of the talent or the growth of that business went outside of Israel, rather than benefiting the local market. So this is on the previous question. On the challenges of companies, of target companies. Well, I think we have two different types of challenges. One is substantial, and the other is technical. So a target, when a target faces the dilemma, then first, often the target is faced with an approach from a SPAC, or just on its own initiative considers that, and then they have to consider whether an IPO or a SPAC, what's the preferred route. And that's from a substantial perspective. So usually when you go down the SPAC route, then you need to start the process. You usually don't go to one SPAC and that's it. So you would like to do it through a big process and solicit offers from various SPACs. So you would need bankers to assist you. You would need bankers to also assist you with analyzing the proposals you get from the various SPACs. Because I don't think companies are equipped or have experience to evaluate the pros and cons of the offers they get. It's not only about the valuation; it's also about the size of the SPAC, the team, the commercial terms, whether they want to have features like a secondary sale or an earnout arrangement. So all of this is something that targets really need to face and to consider from the moment they get into this process. So they would immediately need to engage bankers, to engage lawyers, and then they need to figure that out. So that's another challenge in itself. How do you tailor the right incentives for your advisors, for your bankers? How many bankers do you take? Because there are placement agents, there are advisors that would assist you in the process itself. It also depends on what bankers the SPAC that you will be working with will have, and what will they be able to assist you with. And so I think that's from a more substantial perspective. From a more technical perspective, you would need immediately to start working on the diligence process. This is a very fast process. It's a sprint, it's not a marathon. So you would want to arrange a data room. You would want to start working on financial statements that would be relevant or appropriate for SPACs and will comply with the relevant regulations. You would want to start working on the prospectus, and this is all tasks that will require very fast-paced and working diligently around the clock with advisors. So this is something that should be considered from the outset.
Thanks. And obviously, just like in any other IPO, I mean, the time that takes of management and the focus it takes of management, while at the same time keeping their eye on the business, is always an issue that's got to be balanced by the team when they continue down that path. Roxanne, back to you. Sort of, are there any regulatory challenges that you have to consider, involving the targets when you're looking to pursue a SPAC transaction?
Yeah, I think in the Indian context, Alan, and I suspect that this is, possibly the case in other jurisdictions as well, particularly jurisdictions that, like India, have quite tight regulation around, cross-border investments. It sounds an attractive proposition, and I think, over the last year or so, and particularly I think a few months ago after Renew announced, which was a really big SPAC, and in the Indian context, quite a big deal. We've had a lot of interest expressed, from a number of companies, but I think the reality is that a SPAC structure in the context of an Indian company is quite hard to achieve. We have, again, quite stringent requirements in terms of, how our cross-border merger regulations work, which companies can have which assets, overseas entities cannot operate in India without, physical presence here, those kinds of things. So a lot of the time it does take quite a bit of extensive structuring around what would otherwise, perhaps in the US or the Canadian context be, reasonably simple business combination can be a little bit complicated. So what we've seen, for example, are structures where you need to do what we call externalization. You effectively set up a holdco overseas, and then have a share swap, and then have the de-SPAC transaction actually occur with the overseas holdco. But that in itself can be challenging, because again, there are restrictions around Indians holding investments overseas, with that overseas entity then having a holding back into India as well. So I think in terms of the challenges, some of them are going to be pretty specific and pretty unique to India, just because of the way our foreign investment regulations work. But I think in a nutshell, the requirement for regulatory approvals, I think, can be complicated, particularly as Erez said, this is a very, usually a very tight time frame that you have between, engaging with the SPAC and having to wrap everything up. So typically SPAC sponsors would not be willing to, hang around waiting for complicated regulatory approvals that may not be forthcoming in quite a short time frame. And I think that is probably one of the biggest challenges, I think, from an Indian perspective.
And I think just to your point, to translate that, anyone on this call in a different jurisdiction, and you've got a client that's interested in this, I think one of the first things you have to consider is whether your home jurisdiction has some regulatory hurdles that may make this difficult. Because what the last thing you want to do is kind of start to go down this path and find out you have a roadblock after you've invested a lot of time and energy. So I think it's an important first step. Obviously Roxanne is representing one jurisdiction, but anybody outside of North America should be looking at these kinds of regulatory hurdles as a potential impediment, or at least understand what's going to be involved in order to get it done. David, back to you. Maybe you can talk about some recent trends you're seeing in de-SPAC transactions that have occurred. Maybe you can give a couple of highlights.
Yeah, I think I'll mention a few macro trends, but welcome the other panelists to provide some insight to what they're seeing in their jurisdictions as well. I think the first one, just in the last few years, SPACs, I think, are really being viewed as a viable path to going public. I think prior to that, SPACs were viewed as kind of the second choice after an IPO. Most companies that could do an IPO or direct listing would pursue those avenues. But I think that SPACs really have emerged in the last 18 to 24 months as a viable path to an IPO, or to going public. Sorry. The second one, again, this is all tied really to that US boom that Megan mentioned initially, is just given the number of SPACs, is the geographic reach that they're, that SPACs are now pursuing targets in multiple jurisdictions. And I mean, that's really the result is this panel discussion here. And then finally, I think given the number of SPACs that have IPO'd in the US, the number that are looking for targets, I think I saw a number a few weeks ago that said something like 260 SPACs in the US were going to expire in the next 18 months. I think the targets really now are in the driver's seat. Targets can seek out different SPACs, they can negotiate with different SPACs, play them off each other, and really negotiate the best deal possible for the target groups.
I'll open that up to others. Is there anybody else have any comment on what sort of you're seeing in the last 6 to 12 months, especially given the nature of how many companies have gone public in the tech space and others? Anybody else has anything? Megan, maybe you can talk about the timeline. We talked about it's condensed, and Erez talked about it's tight. Maybe you can take us through sort of a typical timeline, and what are the key factors that are going to influence that timing?
Yeah. So as panelists have mentioned, the sort of initial work needs to begin on the target side to make sure that sort of this is an avenue that you would want to pursue. So that initial work, that internal diligence, legal diligence in your particular jurisdiction to make sure that this is a viable path forward. Selecting an investment bank, as Erez mentioned, is another sort of initial early step that the target should take. Particularly if you're wanting to run what's commonly referred to as a SPAC off process, which is essentially this idea that a few panelists have mentioned, that you want to play multiple SPACs off of each other, sort of have an experienced investment bank in the market, looking at sort of multiple potential SPAC sponsor combinations that might work for you. So that's sort of the initial step. After that point, there's sort of traditional wall cross due diligence process, which takes about 4 to 6 weeks. Once that's done, there's the negotiation of the deal, signing the deal process. That's typically 1 to 2 months. During this period, you would also be working on raising the PIPE. If that's typically the money raised in a SPAC is not enough to consummate the merger with just the SPAC IPO proceeds, which is why it's often coupled with a private equity raise. So that would happen in that next step of the process. Once you have a signed deal, you have your PIPE locked in. The next step is to seek regulatory approval in the US, which is basically through you file with the Securities and Exchange Commission what's called a Form S-4. That includes extensive disclosure about the terms of the merger, the target company. The preparation of that can be extensive. And once you filed with the SEC, it typically takes them 30 days to get back to you on the initial filing. After that, it's typical to see 2 to 3 rounds of iterative comment letter processes where the SEC asks you to refine disclosure, add disclosure. And once you've cleared that process after a couple of rounds, which is usually about 75 days, I would say on the outside, though it can be quicker if you get through that SEC process more quickly than expected. And then once you've cleared SEC review, you're ready to seek shareholder approval. So you notify the shareholders, that there's going to be a special meeting. You would seek a shareholder vote, and then you would close shortly after that vote. That's typically about 2 weeks, 15 days for that part of the process. And as I've mentioned earlier, one of the key dynamics in this process is that stockholders do have a redemption right up until usually about 2 business days before the meeting occurs. So that's sort of the key. That last step is key, a key part of the process to be sort of monitoring where the stock price is, what investor sentiment is about the deal once it's been obviously publicly announced and the disclosure has been out there for some period of time. In terms of factors that can significantly influence the timing, one of the most important things, which some of the panelists have mentioned, is in the US, you're required to have PCAOB, which stands for Public Company Accounting Oversight Board financials. Generally, companies that are going to go through the SPAC process need to be able to generate those financials relatively quickly. Usually SPACs are going to want a company to be able to provide those within a period of maybe max 2 months. So that can be a very significant hurdle for a lot of companies that obviously are not currently, creating US public company financials. Essentially, most private companies are not doing that. Obviously, the SEC timing and how long you're in that review process can be significant. A significant impact on the timing as well. There can be marketing conditions that may impact sort of, when it's desirable to publicly announce the deal, when it's desirable to be going to stockholders. You may be wanting to avoid certain earnings season or market slowdown periods in August or something like that. So those are some of the main points that are driving the timeline that I'm seeing in the US.
David, is there any significant differences in the Canadian timeline, or would you say it's similar? I know the process is slightly different. We're not dealing with the SEC.
Yeah, the process is overall similar. We have to file a prospectus. We clear it with our regulator. It's not the SEC. So generally it's a 1 month process versus I think a 2 to 3 month process. But overall, and we also don't have shareholder meetings, but there still is a redemption right. Overall, it's the same. I do want to just emphasize that financial statement issue that Megan mentioned. If you're going public in the US, you have to have PCAOB audited financials. In Canada, it's IFRS. We recently closed a transaction, a SPAC transaction with an Israeli target, and I think Erez will touch on this structure a little bit later. But effectively, the Israeli entity acquired the SPAC rather than the SPAC acquiring the Israeli entity, just for tax structuring reasons. And the result was a public company that was public in Israel, in Canada, and then was seeking a listing in the US. So we had to, in that situation, think about what financial statement requirements would apply in all jurisdictions and have the auditor make sure that they're forward-looking, ensuring that they're meeting those requirements. So that the financial statement question is a hurdle that always rears its head. It's something that's incredibly important and it's a long pull. So something that people should start thinking about at the outset. If you're a target knowing you're going public, I think it's always worthwhile to look at your financial statements and try to start thinking about what you need to do to get them in public company shape.
And just to be clear, whether you go the IPO route or the SPAC route, financial statements is always the gating item in a lot of these cases. I think the point here is that you're already working on a condensed timeline, and you've got an acquirer that's, you've got a SPAC that if they see a problem, it'll make you less attractive as a target. So I think the key here is that giving that adequate consideration, making sure your auditors understand what's going to be required, and getting their auditors in line with the timeline. Otherwise, that could derail you from that perspective of getting it over the finish line. I think that's a really important point that, as I say, it goes to SPACs, it goes to IPOs as well, but particularly important here, just given the tight time frame. Megan, I'm just going to go back to you. Maybe you can talk about some of the key investor and management dynamics that are considered in a merger with a SPAC. Maybe you can touch on that.
Yeah, so a few things that I think are sort of important to consider if you're considering this SPAC process to go public is one, which I've mentioned a few times, is the redemption risk in a SPAC context. So there's a tendency to think about the de-SPAC process as traditional M&A, a lot of times because it's structured as an M&A transaction. But in a lot of senses, it's actually more of a capital markets process. The reason for that being that in a typical M&A context, you're seeking to maximize price for the company. And usually you would go with sort of the highest bidder for that reason. In a SPAC context, given that there's this redemption risk that stockholders have a right to redeem if they don't think it's a good deal, or they think, that the SPAC is possibly overpaying, or, they're just not happy with the overall sort of structure that's proposed. That there can be reasons in a SPAC that you don't want to sort of go forward with a sponsor that's proposing some sort of unrealistic valuation, because it does create more of a redemption risk, which can affect your ability to consummate the IPO consummate the de-SPAC process and go public through that process. So that's sort of one of the key investor dynamics I think that the companies need to be aware of going through that process, not thinking about it only as an M&A transaction. Obviously, there's tax considerations that companies should be aware of. A lot of SPACs in the US are formed as it's common for them to be US entities, but there's also commonly a Cayman entity might be used. I think in a lot of international contexts, and this would be entirely jurisdiction specific, but there's a desire to avoid having a US company as the resulting entity if your operations are, in another country. And there can be other structuring considerations that some of the panelists have alluded to, ways to sort of have the target be have the existing operating company be the resulting public company in a merger. But those kind of tax considerations and thinking about where the SPAC is organized are important. There are also obviously, having a company understand that by going through this process, they will be a public company. There are a lot of sort of educational things that need to be, the management and the board of the company need a lot of management or need a lot of education about what it will mean to be a public company, particularly in the US, if they're not familiar with what some of those requirements might be. So, having from the beginning companies understand what kind of diligence issues might come up in the process, if there's significant, we've had situations where there's, background check issues that come up with a management team that, a company didn't realize would present an issue as a public company in the US. Or there are just sort of reporting education, what kind of reporting requirements are public companies in the US subject to. So I think those kind of education requirements are really important and should be addressed early in the process so that a company that you're counseling has a good understanding of what they would be getting into by going through this process.
I think the important point there is, again, it goes back to my earlier point about the financials. And people know in an IPO process, I'm going public, Sarbanes-Oxley, I got to know that, et cetera. Sometimes in the SPAC process, you're thinking of it as an M&A transaction. You're not quite thinking ahead as well. This is the way to IPO effectively. And so it's all the same requirements, all the same considerations you have to have, having a board that's got the right expertise at the end of the day, whether it's audit committee or governance. So those are considerations that you may not be thinking about because you're thinking this is an alternative to an IPO, but at the end of the day, you end up in the same place as a public company. So very important point on the education. Roxanne, I'm going to come back to you. Are there any regulatory amendments, that might impact SPAC transactions either beneficially or adversely? I know, again, we're speaking specifically to India, but I think it's important to have examples so others can consider what might be happening in other jurisdictions.
Yeah. Sure. So I think, thus far there've been, over the last, maybe say 12 months or so, ever since the SPAC route has kind of picked up interest in the Indian context, the government has been indicating that they intend to make changes and perhaps hopefully simplify some of the issues that I was talking about earlier in the context of regulatory challenges. The one interesting thing that the government has put out a discussion paper on is potentially proposing a SPAC regime for a special financial zone that we have in India called Gift City. So it's quite unique, in that it is it's a special economic zone, a special financial zone that allows certain trade benefits, tax benefits, and that kind of thing, as might be available to jurisdictions that are not actually in India. And what the government has proposed there is potentially to set up, an Indian SPAC program. So effectively to have domestic SPAC sponsors, set up in Gift City to potentially allow companies to access public markets in India via this SPAC listing route, almost have a mirror program in some sense, to what you have in other jurisdictions such as North America. I think it's super early stage. I think there's loads of challenges with it still, but the fact that I think regulatory bodies and the government are looking at something like that, I think is testament potentially to the popularity of this route.
Erez, is there anything in Israel, given the activity level, that would be either positive or negative from a regulatory perspective that might be coming down the pipeline?
There is an attempt here in Israel, very early stage, to lay down regulatory framework for SPACs, to have Israeli SPACs. But this is really early stage for it to be something that companies consider, and one might doubt the advantages of Israeli SPACs in itself to the Israeli market. I did want to touch, however, on the challenges that, as you rightly pointed out, should be considered from the outset, mainly tax implications of SPAC transactions that you don't normally face when you go down the IPO route. So, for instance, in Israel, a SPAC transaction, the traditional SPAC transaction, where the SPAC is purchasing a company and a target company is paying with shares, this swap of shares is actually a tax event in Israel. So in order to not to face, shareholders would not face a tax event, then the Israeli structure is what we call a target on top structure. So the SPAC, it basically means that the company is purchasing the SPAC, and the company is going public, and the SPAC eventually becomes a subsidiary of the target company, and the shareholders of the SPAC become minority shareholders of the target company. Another issue to remember, which is unique for the US, I don't know, maybe Canada has a solution for that, is the inheritance tax in the US for non-US persons, for non-US citizens. So you would be taxed if you are a shareholder holding a US asset or shares in a US company, you would be taxed. If you die, God forbid, you will be taxed at 40% of the worth of your asset, of your US asset. So this is also a challenge for Israelis, actually not Israelis who are shareholders in companies around the world, not US companies, and then becoming shareholders of a US company, and then being exposed to such an inheritance tax. So I think this is something that not many are aware of, and this is another challenge that Israelis have to face with SPAC.
David or Megan, is there anything coming down the pipe or discussed in terms of changes to the SPAC rules, or are we sort of status quo for now, given some, at least in Canada, relatively recent legislation?
In the US, the SEC has sort of released a few sort of impactful pronouncements recently in the last couple of months that have sort of impacted the SPAC IPO market and the way current SPACs are operating or needing to address their disclosure in their financials. This SEC has indicated that they're looking at a number of SPAC issues. Obviously, the huge sort of boom in SPACs is always the kind of thing that regulators pay a lot of attention to. In the US specifically, one of the big issues that's being talked about a lot is the way that the warrants are accounted for specifically for SPACs. So most SPAC warrant agreements contain terms that the SEC has determined require those to be accounted for as liabilities. Most SPACs had not done that up until that point. That was not sort of the consensus view among the accountants prior to the SEC sort of really probing this issue. So a lot of SPACs are being required to restate financials. There's a lot of talk about when we'll in the US have clarity about what can be done to get equity treatment for those warrants. So I think that's something a lot of on the IPO front, people are really looking out for. But of course, there's with the SEC, that's something they're looking at. There's a number of sort of areas that may change, but nothing that's sort of announced other than what's out there.
Yeah, and on the Canadian side, we haven't had that regulatory scrutiny of the SPACs yet, but we are watching what's happening in the US fairly closely. As I mentioned at the outset, the SPAC rules are stock exchange governed. We have seen some updates really to reflect changes to the US or that have occurred in the US market. In addition, the stock exchanges are starting to look at different types of vehicles, SPAC-like vehicles. In one instance, launching a vehicle that doesn't have a redemption feature but has shareholder approval requirements in addition to that. So I think the stock exchanges are trying to be proactive and either adapt their rules to reflect what market is, or think about SPACs kind of outside the box and seeing if they can expand the market through the development of alternative vehicles, SPAC-like vehicles.
That's great. Got a few more minutes and then we'll take questions. I know there's already a few in the chat here. I'm going to go back to Erez and maybe talk about some of the, I know you touched on a couple of issues, but some recent innovative features you've encountered. Maybe some real life example that we can share with the group, and maybe others have too, but we'll start with you, Erez. It's something that might be of interest here to the audience.
Definitely, yes. So I'll touch on two recent features we've encountered that are very interesting. One is the size of the SPAC. So the size of the SPAC is obviously a very important factor in selecting the right SPAC for you. And then sometimes you found the right SPAC, the right team, but the size of the SPAC, the IPO proceeds, it's just too large for your company, or you may even encounter that problem after you enter into a term sheet with a SPAC, and then you go and try to raise the PIPE investment, and often the valuation that you agreed on is being reduced, and then you find yourself with a too big of a SPAC for the transaction. So for instance, what we can do in a target on top, at least in a target on top structure, then you can the consideration that the being paid can be part shares, part cash, and this is how you force the redemption of the trust account of the SPAC proceeds. So this is one good example of how you face challenges as you go, and try to find a solution to fit your circumstances. That's one example. The other example is that we see earnout arrangements that are not. I think you often see earnout arrangements with respect to the sponsors, but we see earnout arrangements for the shareholders, the target shareholders. So if there is a discussion around the valuation, then this can be settled just by having in place an arrangement pursuant to which shareholders will be issued more shares when stock price will get to a certain price, to a certain level. So this is how you find sort of the middle ground when you have the disagreements around the valuation.
And I think on that last point, it just speaks to the fact that there's a little more bargaining power on the side of the targets than there ever was before when SPACs were more limited. There is this ability to try and negotiate some of these extra economic benefits. Anyone else have anything they want to raise from like a example perspective or anything that's unique that would be of interest to the audience?
So one of the things, Alan, that we've done, and again, in the context of India, where there are restrictions around what we call round tripping, which is Indians holding overseas and then overseas holding back into India again. The routes that companies have been exploring is effectively to have, and this works best where you already have a lot of potentially private foreign investment, PE funds and the like holding shares in the target. But one of the routes that we've used is actually to have a share swap so that we externalize our structure, have a holding company offshore, have the Indian shareholders continue to hold the Indian subsidiary. So the company that actually undergoes the de-SPAC, the company that actually undergoes the merger and becomes the listed company, retains an unlisted subsidiary in India, but not a wholly owned entity. So that company will end up holding a majority and hopefully a vast majority of the Indian target. But the Indian shareholders continue to sit at the target because you can't have them offshore. But then potentially you have, as Erez was saying, structure, earnouts, option agreements, promote arrangements and that kind of thing to eventually give them liquidity because they obviously don't have access to the listed stock at the US company level.
That's great. Anybody else before we move to questions?
I think I'll just add to Erez's point with respect to the earnouts. I think, and Megan mentioned earlier that often you'll have a private placement that will be affected concurrently while you're negotiating the M&A portion of the transaction. And the private placement, often you'll try to raise enough money to kind of hit any minimum cash requirements for the SPAC to so that you don't face any deal risk with respect to the redemptions. We have seen in some recent transactions using the private placement portion, the marketing of the private placement is really, a way to validate value for the target. So you can negotiate what the target thinks is going to be their valuation, what the consideration is going to be, go out to the market it to the extent that that's not, the market isn't receptive of that on the private placement. We have seen people restructure the consideration and then you kind of end up with that earnout. You push some of the consideration that they want into an EBITDA target or even a share price target. But it allows it's almost through a testing the waters process to kind of have a chance to validate your valuation before the deal is even publicly announced or closed. So I think it's a really interesting process from that perspective.
That's great. I've got about 10 minutes left and I see some questions here. So why don't I start with the first one, and it's open to all the panelists. Many SPACs have been trending recently and historically behind comparable index performance. Does anyone want to comment on how sponsors and bankers have been addressing this issue with investors, just given recent performance or underperformance? Throw that open. I know it's more of a capital markets question, but I mean, everybody's close to this, so they might have a view.
I think, as you mentioned, Alan, it is a capital markets question. I would say until, as I mentioned earlier, the last kind of year to 2 years, SPACs have, I think the pedigree of the targets has really increased. And in a lot of situations, you're still seeing targets that are selling their pipe on outlook, several years outlook. They're really kind of emerging market or emerging entities. So it might be a situation where companies just need a few years to really get the traction to build up the business and kind of fulfill the expectations of investors. But I think what you'll continue to see as SPACs become a more consistent, vehicle in our lives, higher pedigree of targets, and hopefully that will result in better results on a post de-SPAC basis.
Okay, I don't know if anybody else has anything, but the next question is, and I'm open again to anyone who wants to comment, what is the typical way SPAC sponsors are compensated? Anyone wants to speak to that?
So I speak from a US perspective, it's common that sort of at the initial IPO, the sponsor typically has about 20% of the equity in the SPAC. So it's typical that they would pay a pretty nominal amount for that initial equity. It's normally in the US structured as $25,000 for 25% of the SPAC entity. So the sponsor is typically a very large stockholder of the SPAC itself. Obviously, there are sort of mechanisms in place that that their equity is generally not redeemable. That equity is not exactly comparable to the public equity. Normally, there's a lockup sort of post IPO that they're required to hold on to that equity. But so part of that compensation is in the form of equity of the SPAC itself, and that's from our perspective, seeing corporate sponsors of SPACs, that's one of the main driving factors of why they want to form these SPACs and go out to market and do acquisitions this way is the potential to own that significant equity piece of the target.
Great.
Yeah, that's the same in Canada, Alan. The only maybe a soft positive would be some sponsor groups are really looking just for access to those emerging companies and kind of getting their tentacles into some entities. So starting SPACs to kind of use that as a vehicle to gain those connections. But the compensation for a Canadian SPAC is the same as Megan described.
The next question is, what would you say are the biggest risks associated going SPAC route versus a traditional IPO? What would be the number one drawback?
I think if you can get through, sorry, Russ.
No, go on, please. Oh.
I think maybe Russ can talk about it from kind of the target's perspective. I think if you look at a SPAC versus an IPO, the IPO, you do all the work. You might go through testing the waters and get a little bit of comfort that there's a market there, but you go through everything, then you publicly announce and you go out and you market your transaction and you raise your money. On a SPAC transaction, you're doing that work. You're negotiating the M&A process. You're negotiating you're going out and marketing your pipe confidentially. So by the time you actually publicly announce the transaction, you should be in a place where you have a significant level of deal certainty. Your M&A transactions negotiated, you've raised your pipe, so hopefully you've met any minimum cash conditions. And from there, I think it's really a regulatory risk matter. You just have to get through, if you're in the US, the SEC review, and if you're in Canada, the OSC review or the other regulator that's reviewing it. So I think those are the biggest differences between the two processes. I think on the SPAC side, it's negotiating that deal and marketing your pipe. But once that's done, hopefully you've structured it in a way that you have deal certainty, versus an IPO where you're really launching publicly and then taking the risk.
Harry, is anything to add there? Or?
No, I think that's the issue.
Great. I don't see any more questions. I know we're at 9:55. I really want to thank the panelists. I think this was a very helpful overview, as I said, across the spectrum for those who didn't have much knowledge about SPACs to those who had some specific questions. Obviously, we're all available if and when anyone in the World Law Group has issues or questions about this, feel free to reach out to any one of us. We can guide you in the right direction. And thank you all very much for attending, and thank you to the panelists, and thank you to the World Law Group for setting that up. So appreciate it.